Welcome everybody to our industry update. Thanks for joining us this month. It's great to have you all here. I'm Jill Cox with Heritage Title. And before I introduce our speaker today, who most of you already know, I would like to make sure and have you save the dates for our upcoming industry updates. So November 4th, we're going to have Paul Bondi on. He's an E&O insurance broker. So he's going to be talking about different coverages and policies. So really helpful information in that one. December 2nd, we're going to have...
I think you need to change your slide.
Oh, sorry. Well, why is that not working? I've got something kind of goofy happening with my slideshow.
Oh, sorry. I didn't mean to interrupt you.
Oh,
there it is.
No, perfect. There we go. Okay. No, thank you for letting me know. So December 2nd, we've got an attorney joining us named Suzanne Leff. She works with HOAs and she's going to be talking about some legislation that has changed with regards to HOAs that will impact our real estate business. And January, we're going to take a little break. And then February 3rd, we have scheduled a gentleman who works for the Denver FBI, who's going to be talking about wire fraud and real estate transactions. So that's going to be super interesting. So save the dates for that. And then I generally don't introduce Damian because I feel like everybody kind of already knows who Damian is. But since he's our sole guest speaker today, I'm going to go ahead and give a little overview on Damian's background in case there are some people on who aren't familiar with Damian and what he does. And I thought I would throw on some kind of fun personal photos instead of those usual, stuffy old headshots. And so there he is cutting some glass there at Chatfield. But Damian is an attorney who has his own law firm, Cox Law Firm, and he is the vice chairman of the Real Estate Commission Forms Committee. He also serves on the education committee, and every year he does the Train the Trainer for the annual commission update course. He's a member of the Real Estate Section Council for the Colorado Bar. He's the owner of Cox Law Firm, which is a boutique firm that specializes in brokerage law and contract law. And he represents more than 30 brokerages all over the state of Colorado, comprising of over 3,000 real estate brokers. And he's also the owner and founder of Cox Education, which is a new school that he launched this last year. That is a continuing education school for brokers in Colorado. If you haven't checked out his new website for that, please do. He's got tons of CE courses coming up and has some wonderful instructors covering a wide variety of subjects. And he has also worked a lot with the Colorado Association of Realtors and the Real Estate Section Council to draft legislation regarding various aspects of real estate that impacts our day-to-day business here in Colorado. So he is well equipped to talk about these contract changes that are coming up. And we're going to pull up here. These are the points of discussion that he's going to cover today. So with that, I'll turn it over to Damian. If you have questions, just put those in the Q&A and we will get to those as we can. So thanks again for joining us today.
If you want, you can pull this down. I'm going to just start by talking about, I'm sure that there's a lot of people out there wondering why in the world they haven't seen the red line contracts yet. And so I kind of wanted to address that so you guys know what's been happening at the commission. So first of all, the contracts to buy and sell are the bane of my existence. We changed, there's a lot of changes this year, guys, some fairly substantive. And what happened is we changed a paragraph that changed the references throughout the contract. And there's 5 of these forms. And so editing this year took a little longer than normal. Normally, we'd like to get these things released about October 1st. This year, it took a little longer. And then we were also thrown a curveball. Because as we were going through editing and everything, we realized that the head of the editing committee forgot to put the residential addendum on the forms list as far as things that needed to be changed back in June, because he's just a downright idiot. And so we had to get a residential addendum approved in October. So the commission approved that on Tuesday, the residential addendum. We had another form that had to go back to the commission because it turned out that there were some things that had to be changed in it as well. Both of those forms were approved on Tuesday. So I don't have any red lines to share with you guys today because they literally have not yet been released. I do expect that they'll be coming along. It should be this month, or actually it should be this week is what I'm thinking. I'm hoping even as it should be tomorrow, if not Monday at the latest, but I'm actually going to check on that as soon as we're done with this call and figure out where that stands and see when they're going to be released. Once they are released, Jill will send everybody on her industry update a link or something notifying you guys that they're up. And it's important that you take a look at them because, like I said, there are a lot of substantial changes in it. One other thing I wanted to tell you is that the Forms Committee was also approved on Tuesday. I do not know who's on the Forms Committee. As a lot of you probably saw, there was a call that went out for people to apply to the Forms Committee. They try to keep the committee about 20 people so that it doesn't get overwhelming. And they try to do diversity amongst people as far as areas and expertises and that kind of thing to make sure that the Forms has different viewpoints on a whole bunch of different topics. And there's also a lot of people that are even outside of real estate brokers that are on that committee. I do not know who's officially on that list. When they approved it on Tuesday, I will tell you there was over 200 applicants, from what I understand, for the positions that were available on the Forms Committee. I do not know who was approved because what they did in the meeting is they said to approve the slate as presented, but that list was never really released. So, somebody says they know who the volunteers were. So Marcia sent out the list yesterday. There we go. So apparently the list is out. And if you want to see who's on the Forms Committee, you can see it there. Thanks for that, guys. Okay, so let's go ahead and we're going to start with talking about what's changed in the contracts. Now you can pull up my little slide. Nifty glifty slide.
Oh, okay.
So we're going to go over some of the more substantive, more important provisions in the contract. This is not an all exhaustive list. And I want you guys to know this is a 30,000 foot view of some of the changes in the contracts, just so that you guys are starting to get familiar with what's going to be updated in the contracts. Last year, if you guys will recall, when we had this session, I told you guys, don't worry about taking a contracts class because there just wasn't much that had changed in the contracts last year. And it just, unless you were doing manufactured homes, it didn't make sense to go take a contracts class. That's what it was last year. This year is different. This is the contract to buy and sell. This is literally your lifeblood. And there are a lot of substantive changes. And I think there's going to be some things that are so new or so different that it could cause problems for you if you don't understand how those provisions work. If you don't have time to take a contracts class or don't want to, I certainly understand that, people get busy. I would at least make sure you download the red line versions when they do come out and take a look and make sure that you know what's in there and you get familiar with it. Read the provisions carefully, understand how they operate. Okay, so with that, we're going to do our 30,000 view, and I'm going to talk about a couple of the changes. The first one that I want to talk about is what's called time of day. So this provision comes from how many out there, I'd ask the question, but I can't even see how many names go up or hands go up, but I'm going to ask it anyways. How many out there have had, it's an inspection objection. It's sent to you on one day, the resolution shows up, or the resolution is 3 days later, and you guys are up until 11:30 at night waiting to see, is the seller going to send over a resolution, or is the buyer going to sign the resolution? Or are they going to withdraw their inspection objections? And it's been a real, particularly around inspection. I mean, that's where I hear most of these issues coming up, but it's been a real problem with brokers having to deal with contract, either extensions or deadlines or resolutions or something in the 11th hour of the contract, because they just, because the contract says that the day ends at 11:59 Mountain Time. So that's the point of this new time of day deadline that's put in there. And what you have is you have the dates and deadline chart, and the first one at the top says time of day. Now, so the time of day is something you can put in. Now, you need to read the provision closely in 3.3, because what it says is that it doesn't apply to all the deadlines. It only applies to some of the deadlines. So I think this is a really good change for our industry, but I do think, number one, it's going to take some getting used to as people navigate this. And number two, you're going to have to make sure you're very careful about understanding what those deadlines are that it applies to. and also keeping track of what the time of day is in your contracts. When the Forms Committee passed this and the commission approved it, what they did is they made that time of day negotiable, meaning that you could put in 5 o'clock, 6 o'clock, 7 o'clock, 8 o'clock, 9 o'clock, whatever. And so if you're doing multiple contracts, you can see where all of a sudden you have one that's at 5 and one that's at 7. If you get them mixed up, that could cause you all sorts of problems, missing deadlines or something. So my hope is that the industry is going to find an equilibrium as to what that day is or what that time is. I don't know what it's going to turn out to be, but just make sure you're keeping track of that. Make sure you read that provision very closely. I do think it's a good change. I think it's going to help you guys with inspection a ton. But you don't have to wake up your buyer to try and get a resolution signed at 11:58. So that's a good thing, but it is going to take some getting used to, and there is some trepidation in there, I will say. So keep that in mind. Hey, what was my next point?
1 second.
Isn't this bad? I don't remember. Oh yeah, leased items and encumbered inclusions. So one of the things that our contract has kind of been a little short on, or not real good about, has been when we have, and I'll tell you that the primary thing for this leased items and encumbered inclusions all stems around solar panels. It's an area that, we have solar panels. A lot of houses have solar panels. Some of them are completely owned by the seller. Some of them are leased. Some of them have loans against them. And there just hasn't been a good way of dealing with that in the contract. We've had the checkbox in 2.5.1 that essentially said, oh, if the solar panels are owned, check the box. And then you have water softener, security systems, et cetera, which was okay. So the seller owns it. And then we had another paragraph that talked about inclusions that were encumbered, but it was just a quick line that a lot of people overlooked. Leased items, it said, oh, if they're leased, don't put it in here. And it's supposed to end up in due diligence. And it was really, really awkward, to say the least. And as solar panels have become more and more a part of our industry and more popular, the contract needed to adjust to kind of address these things. I will tell you, there's essentially 3 different places in the contract that now address solar panels. You're going to see paragraph 2, where it talks about where you list the leased items and you list the encumbered items, say what's encumbered and how they're encumbered, et cetera. And then you're going to have new provisions in due diligence that talks about delivery of those documents, because that was never really clear as to how that worked either for a lease on solar panels. So it tried to clean it up to make it a little easier for brokers and, more importantly, sellers and buyers to understand what happens with those solar panels and those things. There's another area in there that talks about leases and assignments and those kind of things. So again, this is a paragraph that there's 3 different places in there. You need to look and read each paragraph to see how they interact and work together in there. And it's another one that's probably going to take some getting used to, because it's just not something we've had the ability to do before. In the past, we've had additional provisions that were added. We've had things put into due diligence that were added. We've even had stuff in inclusions that were added. This now has standalone paragraphs that have their own operation. And hopefully we addressed everything in there that needs to be addressed in those circumstances. But we'll see how the industry adapts to this in the coming year. Needless to say, with any of these changes or any of the forms in general, if you guys are using these things and find things that are clunky and not working correctly, I want to encourage you to send comments to the Real Estate Commission and try and get stuff on the global list. As the Forms Committee, we do look at those suggestions that you guys make and try to address those as we go. Okay. Any questions on that before I? Doesn't look like it. Okay. So another paragraph that changed talks about the failure to release earnest money. I'm going to tell you, I don't, this provision, well, let me step back a minute. So failure to release earnest money is one of those things that we've had, particularly in this market, right? You've seen a lot of people just get angry And so you have sellers that refuse to release earnest money because they think that the buyer has been acting, hasn't been acting in good faith, or they missed a deadline, or whatever the case may be, but they want to hold that earnest money. And you have buyers that might terminate for no reason, but then they think that they should get their earnest money back. And it's been difficult for brokers to navigate that. They want to represent their clients, they want to help them. And it's difficult to go tell your client that, hey, you're being a butthead and you need to release this because you don't really have grounds to keep it. And that's legal jargon in case anybody was wondering. But it's the problem is obviously that, when your client doesn't have a right to retain the earnest money, you don't want to be the one to be the bearer of bad news, so to speak. So one of the provisions they added in Section 4 has to do with the failure to release earnest money. Now, what we had before, if you guys will recall, there was this provision that said that, if the buyer sends a notice to terminate, then the seller has to sign an earnest money release within 3 days if they don't have a dispute over the earnest money. And it was a provision that has been used quite a bit for brokers to point to and say, hey, seller, you have this obligation to sign this because of this 3-day requirement. Well, now it goes both ways and it's been more formalized. What we have now is a paragraph that it'll have something that says seller failure to timely return earnest money, and then you have a buyer failure to timely return earnest money. And it's more formal instead of the old contract where it was kind of in one provision in a sentence somewhere. This is going to have it somewhere where it's spelled out as to what happens if they fail to return it. All of that being said, to me, this paragraph is more of a tool to use with your clients to help advise them of what could potentially happen if they don't return the earnest money and they wrongfully are holding it or wrongfully demanding it. The reality is it's no different than the contract was before. Our contract has always been if the earnest money belongs to the seller and the buyer says, I want the earnest money, and they go to court and the seller wins, and the buyer could be obligated for attorney fees. That's the same as it's always been. So this provision, I think I view it as more of a tool. This is a way to help the brokers educate the clients about the risks associated with wrongfully demanding earnest money. However, it really doesn't change the operation of the contract as far as what has to happen or what should happen with the release of earnest money. So hopefully, honey, I didn't make that sound just all over the place and everybody's like, well, why didn't I just read the forms? That'd be a lot easier. But anyways.
I think it was great.
Okay. What's my next point? I'm sorry. I have to have your slides because apparently I'm not well prepared.
Am I sharing the right one?
Yes, this is it. Okay. Absolutely. Okay. Oh yes. New loan terms deadline, new loan availability deadline. So this is another big change. So go ahead and so here's the problem. So the problem we've been having is buyer rights contract. Buyer has contingencies. One of those contingencies used to be what was called the new loan termination deadline. And as you guys all know, the new loan termination deadline was usually up to closing, maybe a week before closing or sometime a week in between there, 3 days, 4 days, whatever, before closing. And what that clause said was that the buyer, in the buyer's sole subjective discretion, has a right to terminate the contract if they don't like the interest rate. And as I'm sure a lot of you are aware and have dealt with, you run into this problem where the buyer now either gets cold feet, or they didn't like the way inspection was resolved, or they missed a deadline on something else, or whatever the case may be. All of a sudden, this loan termination pops its ugly head up again. And the buyer all of a sudden comes in without any explanation, says, oh, I'm terminating based on the loan. And the seller says, well, wait a minute, what do you mean? What are you terminating on? They said, well, we didn't like the interest rate. 2% was just too high for us. It just was too rich for our blood. We were hoping it was going to get into the ones. And because it was sole subjective discretion, and it was just this thing that was left totally to the buyer to decide whether or not they could terminate, it made it really difficult for sellers to say, wait a minute, I think there's something fishy going on here. So this clause is meant to try and handle that. So now, instead of having a new loan termination deadline, what you have is a new loan terms deadline. So the new loan terms deadline essentially says, hey, buyer, if you don't like the terms of your loan being offered, interest rate, interest rates, the payment, whatever it is, the subjective stuff, the stuff that a buyer, in all honesty, if they went and got a loan and found it was 10%, they might be like, oh, I'm not doing that. That's ridiculous. And so those subjective terms are now in this new loan terms deadline. You also now have this new loan availability deadline, and this one's more objective. It's more of a, if the lender can't give you the loan, then that means that you can terminate. So what I see happening with these two deadlines, so first of all, as a lot of you know, we got a good faith estimate that when the lender makes, when the buyer makes loan approval, the lender has to send out their good faith estimate within 3 days. And so that makes it really easy because they're going to have all the terms all available to them, or the terms on that sheet within 3 days after they make loan application. And so we can now push the new loan terms up in the contract and say, hey, buyer, that's fine. You can approve your terms, but you're going to do it earlier in the process. You're going to do it after the lender has committed and said, this is what we're going to do with this provision, or this is what we're going to offer you on these terms. And then that makes it so that the new loan availability deadline can now be out where the new loan termination deadline used to be. And hopefully it takes out some of that subjectivity of the new loan contingencies. That's the intent of it, I can tell you. Whether it work or not will remain to be seen. But the point is to try and bifurcate it so that, okay, subjective, that's fine. We'll give this to you, buyer, at the beginning of the contract. If the lender has a problem with availability, we understand. We'll let you out then, but it has to be more objective about the availability of the loan. Now, guys, I'll tell you, I think buyers can still play games with this, probably, but I think it's at least tightening it up a little bit so it's a little closer. I see a question.
You did see a question. The question was, what would you suggest to use for date range on the new loan terms date?
So the new loan terms date, okay, so I was talking about that. I'll answer it again because I think it bears repeating. To me, how about a week after you go under contract, maybe 10 days, maybe you make it up to inspection so that they have that same period as their due diligence period, that you could do it up to inspection objection. But I wouldn't give them out until the end of the contract like we've been doing before, because it's subjective and the lender should have supplied all that information already. I will tell you, with commercial, it gets a little bit more complicated because they don't have the same regulations as the good faith estimate. But I do think you could still use that provision to push the subjectivity up in the contract. And that's kind of the point of it, is to say, hey, buyer, if you're going to get out based on the interest rate, do it earlier. Don't do it at the time that we're getting ready to close, because it's going to just lead to me wondering whether or not you're really terminating for good faith.
Couple more questions. What do you mean by the term availability?
Okay, so term availability in the contract it talks about, is the loan available? Is the lender able to fund the loan? That's where it's going, is it's more objective in the fact that the lender has said, oh no, you can't get the loan. Then that would mean, okay, buyer has a right to terminate because the lender, because sometimes they're schmucks. I know maybe there's some on here, so I apologize, but sometimes lenders just don't perform or aren't able to perform, or whatever the case may be. And, our industry tends to not want to punish a buyer for the actions of a lender. And that's why we've had this new loan termination deadline out until close to closing for so long, is because, buyer brokers are like, look, I can't put my buyer at risk for something that he can't control with the lender. So this is meant to be about the lender. It's meant to be about it being available, or the lender can fund it. So if the lender gives a clear to close letter, it's going to be tough for the buyer to terminate.
Is there an obligation under the new loan availability deadline for the buyer to prove that their loan was denied?
There is, let me see. There is not anything that says that there's a requirement to show the seller anything, but it does have to be based on availability. So my suggestion, if you represent the buyer, is this: I would not rely on this provision to get out of jail free card. This is not going to be your way to terminate a contract anymore on availability. And while it doesn't have a requirement, there is a good faith component to this. And remember, all they have to do is subpoena in the lender or call the lender, which is normally what happens, and say, well, could they get the loan? And if they get a clear to close, there's a problem. So I think the forms committee stopped short of making a requirement that you show that the loan was denied. My guess is it's about privacy issues and everything. I apologize. I don't remember exactly why we did it, but it's more, it doesn't have that in there, and there was a reason. That said, it still has to be based on the availability. So, if the lender, which happens a lot of times, the listing broker calls up the lender and says, what happened? We just got a termination. So I don't know, we're ready to close. Well, now that's going to be a problem because they can't just claim it was based on the interest rate. Like I said, guys, this isn't going to end all the shenanigans, but I'm hoping that it will at least end some.
Here's a question. Will those new deadlines apply to new construction loans as well?
Well, I guess we're talking about the contract to buy and sell, so I don't know how a new construction loan applies to a residential contract. I guess if you're putting it in I guess I don't understand how what the application would be there. Obviously, if you're using new construction loan to purchase a property, I guess it would apply, but I'm sorry, I don't understand how a new construction loan is going to apply and be applicable in one of our contracts for purchasing property. Usually those come after the property is purchased.
So how is a low appraisal handled with the new loan term provisions? Buyer can terminate at loan availability deadline?
No, it's the same as it's been now. So right now, under our new loan termination deadline, there's literally language that says that the buyer cannot terminate the contract under the new loan based on a low appraisal. So none of that changes. You still cannot terminate a contract based on new loan if it's because of the appraisal. So if your appraisal comes in low, your rights to object and terminate are all under the appraisal provision in paragraph 6. That's the place that you have to exercise those rights. If you wait until the new loan termination comes along or the new loan availability comes along, just because it's not available doesn't necessarily mean you get your money back. If the lender says it's not available because the appraisal was low, you're still stuck. You still owe the money. Buyer has still got risk of losing their earnest money because our provision literally says that that's not in here. You can't use low appraisal as justification for a termination on the loan.
Amanda commented, I would imagine they mean a new home with a final mortgage, not a construction loan. It shouldn't be any different than a resale loan for new construction.
Yeah, it should be the same. The only thing I'll say on this is that, frankly, if they're doing a new home, they shouldn't be using our contract anyways. The builder should be using a contract that's drafted by their lawyer or an addendum that's drafted by their lawyer. And the provisions might still work, but if you're representing the builder, make sure they have a builder contract because these don't work for that. So, yeah. And as Susan says, yes, builders have their own. They should. Not all of them, Susan, have their own contracts. Some of them think that they should use ours because they don't want to pay an attorney, and then it ends up badly. Also ends up badly for the broker, by the way. So if you're going to deal with broker or builders and you're representing them, make sure that you at least advise them they need their own contract. Okay. Inspection objection. So I love this provision, but yeah. So I'm going to tell you guys what the problem was, because I want to back up and help you understand why this changed. So currently under the contract, we have an inspection objection, we have an inspection termination, and we have an inspection resolution. And under the current contract, it says that you can get rid of all of them or you can keep all of them. And if you do an objection deadline or a termination deadline, it says the termination deadline cannot be later than the resolution deadline. That's what's in the contract. It's dumb, but that's what's in there or currently. But the problem was this, is that so what people were doing, despite my advice and best efforts, was they were putting an objection deadline here, and then they were putting their termination resolution deadline here. And so what was happening is the buyer was objecting, And then they were working on resolution. And sometimes it was the seller was out there, he's, checking the roof and looking for contractors, finding out how much time it's going to take. Sometimes they would agree to all the objections, but then the buyer would come back and terminate based on the fact that they had a right to terminate up until the resolution deadline. Or they would reach a resolution and then they would terminate after the resolution was reached because they reached it 2 days before the resolution deadline. And that was creating all sorts of problems, questions of bad faith. Does everybody see how if a buyer gives an objection and the seller is working through in good faith to try and offer up something, and the buyer just terminates for no reason, sellers were upset. They were like, wait a minute, that's not good faith. Wait a minute, we agreed to everything. Wait a minute, why can't we respond to the objection? So it was creating all sorts of headaches for a lot of different people. And I think on a legal question, I haven't known of a case that it went to, but on a legal question, I do think there's a question of whether the buyer is acting in good faith that they just terminate. Because I do think a bunch of those buyers will send their objection. And after they sent the objection, they get remorse and they'd say, gosh, you know what, maybe that wasn't enough. And, oh, maybe we just shouldn't buy this property anyways. And so then they send a termination. And that's bad faith. And I think that it was actionable in court. And so the contract had to be updated to take care of this problem of an objection and then a termination. And so what they came up with was they said, okay, what we're going to do is we're going to say, if you object, buyer, you no longer have a right to terminate no matter when that deadline is. Okay, so they took out the limitation when the right to terminate could be. The minute you send an objection, there no longer is a right to terminate because you've chosen this path of objection. And at that point, you're on the path of you either object and you don't work it out and the contract automatically terminates, or you reach a resolution. There's no more terminate. Now, one of the reasons that we've had this, I'm going to go out of order, honey, but one of the reasons that this has become a problem is because for some reason, our industry thinks that in order to end a contract, we have to have a notice to terminate. You don't. In fact, there's several places in our contract where it automatically terminates. So if it automatically terminates, then that means that you don't have a notice to terminate because nobody has a right to terminate. And so if it automatically terminates, the only thing you need is an earnest money release. And so keep in mind, you can always end a contract by signing an earnest money release. Buyer enters into the contract, sellers into the contract. The day after they enter the contract, the buyer says, you know what, this sucks. I don't want to buy this property. And seller says, you know what, this sucks because I can't find anything. They say, you know what, let's end this deal. Earnest money release, deal's done. You don't need a notice to terminate. Likewise, buyer enters into a contract, seller enters into the contract. Buyer goes through all the contingencies, gets through everything, gets loan approval, gets up to the day of closing, looks across the table at the seller and says, I hate this house. I hate you. And the seller says, I hate you too, and I love this house. Let's just call it off. Then they can say, okay, sign an earnest money release, deal's over. We got to change our mind frame about the earnest money release. It's not just to release earnest money. It's also essentially a mutual termination. That's what that document is. And so I'm going to talk about it now because it's one of the documents that changed. And one of the things that the reason it changed was to try and clarify for everybody that you don't need a notice to terminate every time you want to end a transaction. You don't need it. And sending over an earnest money release and saying, hey, seller, would you like to get out of this deal is not bad faith. And you say, hey, seller, you want to get out of this deal? Because I kind of want to get out of it. And seller says, nope, I'm holding you to it, saying, okay, well, we'll move on. But what I'm seeing a lot of is people sending over notices to terminate when they don't have a right to terminate, or checking the other box because, well, nothing else fits. So we'll just put that in there. And that doesn't work. That's not the way our contract is designed. The notice to terminate is a notice. It is not a termination. And it is only effective if somebody has a right to terminate. So I kind of got off track there a little bit, but that's where this objection and everything comes in, is that, so if you have an objection, buyer no longer has a right to terminate. Once they send the objection under the new contract, they can't terminate. But let's say that the buyer and seller are loggerheads. They just can't make up their mind. Seller says, I'm not doing anything. Buyer says, are you kidding me? You really should repair the structure. I mean, that's kind of important. I don't want the house falling on me. And seller says, yeah, but that's why I'm selling it. I don't want to do that. Well, okay, you can't do a notice to terminate anymore. That's true, but you can still do an earnest money release. And so you can go ahead and have the buyer say, fine, we're not gonna figure this out. Here's an earnest money release the money back to me, seller, and let's be done. And the seller can sign it and you can be done, or that you can wait until the resolution deadline passes and then be done. So that's why that's in there, is because the conflicts it was creating. But you're not gonna, if you send an objection, you don't have a right to terminate anymore. I see some questions, and I think I had a couple in the chat too.
Yep. So with FHA or VA, where the appraisal does not meet the offer price, they can negotiate, correct?
FHA and VA has its own appraisal provisions, so that they still don't have a right to terminate under the loan provision. But what the appraisal provisions for FHA and VA say is that if it appraises low, then yes, they can negotiate and the seller or the buyer can try and come up with money. But those provisions say that the buyer is not obligated to come up with money. So the buyer gets to closing and says, you know what, I'm not coming up with this extra $5,000. Seller can't hold the earnest money of the buyer. If it appraises low, buyer gets their money back, period. Unless the buyer in their sole discretion chooses to move forward and close. But those, again, those are all under appraisal provisions. They're not under loan provisions.
So would the buyer still have the right to terminate in lieu of inspection objection?
Yes, of course. So that doesn't change the way that the contract operates as far as they can object or they can terminate. So if they decide not to object, and let's say for some reason somebody put the notice to terminate out to the resolution deadline for some ungodly reason, then if they didn't object, then they could wait until the termination deadline, then they could send their notice to terminate. It only operates to eliminate the notice to terminate or the right to terminate if they send an objection. But I'll tell you guys, for this reason, whether you're a seller broker or a buyer broker, I put objection and termination same date. I've been preaching that for a year. It's the same advice. And the reason for it is on that day, I want the buyer to choose a lane. Are you objecting or are you terminating? Make up your mind. And then let's move forward with that lane.
Should we push out the appraisal deadline to the new loan availability deadline, just in case the appraisal is low?
Well, now you're getting into, this is negotiations, right? We have a whole bunch of people doing appraisal gap guarantees right now, and I don't think they're going to want to push out their appraisal negotiations. So, if you represent the buyer, sure, it sounds great. I think that works well. As far as making sure that you have that flexibility. You represent the seller, I'm thinking you're probably not going to be a fan of that. So, to me, it's negotiate the best terms that you can negotiate for your client based on the market conditions that we're in.
So with regards to the earnest money release, if the seller does not sign, will title return the money to the buyer after 45 days?
I'm not sure where 45 days is coming from. That's not a deadline in any of our contracts. We have 120 days. And that's only, so if the seller doesn't sign the earnest money release, then the title company has 3 different options, and you need to read that provision on earnest money releases. And one of those options is they can send notice, and then if they don't get a summons and complaint within 120 days of sending the notice, they can return it to the buyer. But it's not automatic at all, and it isn't something that the title company even has to do. So if you have questions about return of earnest money, you need to read that provision.